Hello everyone, welcome back to Legum Prudentia. Today we will learn about case commentary. So in this session, the first thing is what is a case commentary? So here is the answer. A case commentary examines a court's decision, summarizing its facts and holding, identifying the legal reasoning and critically evaluating whether that reasoning is sound. So basically a case commentary is a conclusion of court's decision, facts, holding, legal reasoning, and other related facts. Unlike a brief or a summary, a commentary must take a position, however measured, on the correctness of the court's reasoning. There is two concepts, case brief and case summary. Case brief is a private study aid, facts, issue, holding, reasoning, noted quickly for oneself. This is what a case brief is. Now, case summary, purely descriptive, reports what happened without evaluating it. But case commentary is different. It's analytical, takes a critical position on the court's reasoning and its implications. Now, why it matters so much? First, the main thing is choosing a case. Why case commentaries matter? Trains the core skill of separating what a court decided from why. A recurring assessment format, moot courts, journals, internships. Builds the habit of reading judgments critically, not just acting holdings. So case commentary is important because of moot courts, journals and internship. Also, while making a case commentary, we gain a skill of separating what a court decided from why. The third thing is habit of reading judgment. We build a habit of reading judgment critically. So that is why case commentary is very important. Now choosing a good case. Resolve an unsettled or conflicting question of law. Overrules or meaningfully departs from precedent. Has significant practical or social consequences. Contains a notable dissent worth engaging with. Has comparative interest across jurisdiction. So if you are choosing a case law for your case commentary, try to relate this point with your own case law. Now here is a practical tip for you all. Prefer recent decision from a superior court or ones that have already attracted academic or media attention. This gives you an existing commentary to engage with critically. So this was a tip for you all. Now, standard structure of a case commentary. The first thing is, which is very important, is citation. What kind of citation you will use? For someone who is situated in India, you can choose Blue Book 21st edition. But if you are not situated in India, you can use Oscola. And then comes introduction. You need to write a brief introduction of your case law which you are choosing. Then facts related to your case law. Then comes procedural history. After that, issues and then holding and decision. After all these things, ratio decidendi, then analysis and critique. Broader implications. You can add all these points. And after all these 9 points, you need to add your own idea in conclusion. Then comes bibliographies and footnotes. So this is the whole structure of a case commentary. After structure, what we need to learn is the drafting process. We can divide it into 6 phases. First phase is read and cite. Read the judgment, draft the citation. The second phase is set the scene, introduction, facts, and procedural history. After this, frame the law, issues, holding, ratio versus obiter. Then, fourth, analyze, doctrinal, comparative, or policy critic. Then, fifth, zoom out, broader implications, conclusion. And then, last, polish, citation, footnotes, final review. So, whenever you are writing a case commentary, first you need to read. Just go check, uh, just go and check your case law and read it very carefully, and also draft the citation. After all this, you need to write down introduction, fact, procedural history, issues, holdings, ratio, and you need to analyze it is doctrinal or comparative or policy critic. After all this, you need to zoom out and then you need to polish it. Drafting the fact section. The materiality test. Ask for each fact. If this fact were different, would the court's reasoning or outcome plausibly change? Whenever you are drafting a case commentary and you are adding a fact, try to ask this question. And if you find the answer yes, you can add those facts. And if you are finding the answer no, then it's not very useful for you. You can skip that. If no, the fact belongs in background color at most, not in the fact section proper. Length guideline. Fact should rarely exceed 10 to 50% of total word count. If facts consume a third of your commentary, the analysis is underdeveloped. So you need to think about your length guideline. Whenever you are writing facts, try to make it 10 to 50% of your total word count. Here is a discipline checklist. Include only material facts, present facts strictly chronologically, use neutral descriptive language, separate facts from procedural history if complex, disclose any deliberate scope narrowing. Whenever you are drafting a case commentary, try to use this checklist for yourself. Then, ratio decidendi versus obiter dicta. Ratio decidendi is the legal principle necessary to the court's decision on the facts before it, binding on future courts, or strongly persuasive in mixed civil system. And obiter dicta is other observations made by the way not necessary to the decision, persuasive but not binding. Some obiter later becomes highly influential. Here is the third test, the reversal test. Ask if this statement of principle were removed or reversed, would the outcome for the parties change? If yes, it is likely part of the ratio. If the outcome is unaffected, it is more likely obiter, however often it is quoted. Now, building the analysis, the heart of the commentary. First thing is doctrinal consistency. Consist with prior precedent, any silent departure. Whenever you are drafting a case commentary, doctrinal consistency is very important. The second thing is internal coherence. Does the reasoning actually support the conclusion? Third thing is comparative perspective. How do other jurisdictions treat the same question? Then fourth, policy implications. Practical consequences for future litigants and the public. Dissent and concurrence. Does it expose a weakness in the majority's reasoning? And the last one, academic engagement. Agree, refine, or push back on existing scholarship. So, this sixth process is for your own analysis building. Now, adapting a structure to different case types, constitutional or public law, separation of powers, institutional competence, standard of review, then contract and commercial, certainty and commercial predictability, affect on standard form contracts, tort or delict, structure around duty, breach, causation, criminal law, precision or burden, standard of proof, separate sentencing from liability, statutory interpretation, identify the interpretive method used, note reliance on legislative history. Now comes citation styles. We have many kind of citation styles. First is blue book. So blue book have so many variation also, but right now blue book 21st edition is very popular. Jurisdiction is United States. Example for blue book is Brown versus Board of Education. Then comes Oscola. Jurisdiction is UK and Commonwealth. Then come ILI, Indian style, India. Then AGLC, Australia. APA, adapted, interdisciplinary. Always confirm every citation identifies parties, year, volume, reporter, page, paragraph at deciding court regardless of style. APA is very popular for interdisciplinary approach. A student from any subject can use APA. If you are from law background, it's also fine for you to use APA. And if you are from another background, like if you are from history or polity, you can also use APA. Now, common mistakes to avoid. Writing a summary instead of a commentary. Second thing is an unstructured wall of text analysis section. Mixing citation style within one piece. Excessive quotation instead of original analysis. Confusing ratio with obiter. Ignoring existing academic commentary. A conclusion that introduces new arguments. Here is a practice exercise for you. Select a recent Supreme Court decision with public attention. Draft facts plus issues in no more than 200 words combined. State the ratio in one sentence. Identify one obiter passage. Draft a two-point analysis, each with its own subheading. Add a short comparative paragraph for another jurisdiction. Draft a conclusion in 100 words with new arguments. That's all from our side. Read critically, argue precisely. A strong case commentary distinguishes what a court decided from why and is willing to see whether the why holds up. Thank you so much.